רוצה להתחיל להודות למארגני הכנס, גם מבית לוחמי הגטאות וגם מאוניברסיטת חיפה, במיוחד ענת לבני, אריה כוכבי, חנה יבלנקה, שהם גם ארגנו כנס נפלא, ונוסף לזה הם גם כן עושים עבודה נפלאה. אני מבקשת סליחתכם על זה שאני אתן את ההרצאה באנגלית. לאלו שהיו בכנס אתמול, אני לא כמו פפרמן, שאפילו שהשפת אם שלו אנגלית, הוא יצא בעברית פעם הבאה, אוקיי? אבל בלי נדר, כמו שאומרים אצלנו. On April 11th, 1961, a packed courtroom in Jerusalem, in the theater of Bet Ta'am, Jerusalem's new cultural center, witnessed the beginning of the trial of a man accused of being the chief operational officer of the final solution. 39 years later, on that same day, April 11th, 2000, a packed courtroom in London was the scene of a decision handed down by the High Court, a 350-page decision by Judge Charles Gray in David Irving versus Penguin Books and Deborah Lipstadt. Both these trials took place against a backdrop, however oblique, of the Nuremberg tribunals. We have spent much of the past 2 days analyzing the impact of the Nuremberg proceedings. By comparing and contrasting events in Nuremberg with those in Jerusalem and in London, I hope to show some of the stark differences and similarities amongst these three legal proceedings. Today, I'll spend the bulk of the latter half of my presentation on Irving versus Penguin and Lipstadt, but I shall begin with comparing some comments about comparing and contrasting Eichmann and Nuremberg, some of the things we've heard already, some we haven't. Before I turn to this, I know when it comes to Irving versus Penguin and Lipstadt, I am, as we say, nogat badavar. I am intimately involved in the matter, and that's both a detriment and an asset to my analysis. No one had a better view of the way in which that courtroom, the events in that courtroom in London, would emerge. For the 5 to 6 years of this legal battle, it consumed the vast majority of my personal and professional life. I was intimately involved in crafting the defense, and most recently, just a few months ago, sat in London on a movie set as a movie was made about it, and that was truly an outer body experience. Yet I'm also, so no one probably has a closer and more intimate knowledge of this this trial, this third of these three legal proceedings. Yet, as a historian, I know that often those who are most closely and intimately involved with something are not the best ones to give analysis. We try to claim that we come to a topic tabula rasa. I know that certainly in this case I'm hardly tabula rasa, and you will have to decide whether my analysis stands up even with my intimate involvement in the case. But first, Nuremberg and Eichmann. Why was the Eichmann trial, coming as it did so close to Pesach, different, manishtana, Eichmann from Nuremberg? Some of the differences were connected certainly to the when of these two events. Nuremberg occurred in the immediate aftermath of the war, as you all well know. Europe was in shambles in 1945. Displaced persons were seeking either to return to their homes or to settle in new places. Soldiers who had fought the war and victims who had survived were very much inclined to focus their energies on the future, not the past. In 1961, at the time of Eichmann, the war was increasingly a memory. Europe was stable. The first generation of baby boomers, the generation born after the war, was in their adolescence. In America, certainly there was increased attention by 1961 on the issue of civil rights and discrimination, which gave the Eichmann trial an added relevance during this early period. When the Eichmann trial opened in Jerusalem, there were more reporters present than had been present in Nuremberg. Certainly there was more room to accommodate them. They had better situation, etc. Of course, many of them disappeared shortly thereafter because of the Bay of Pigs and Yuri Gagarin, but in the opening, there were quite a few there. But there's also the who's who of these two trials. At Nuremberg, there were multiple defendants in the dock, as we saw, as we know. In Jerusalem, one man stood alone. The difference in optics, in vision, how it looked, cannot be denied. Whereas at Nuremberg, also the charges are quite different. At Nuremberg, as you well know, if you didn't know before these 2 days, you certainly know it by this point. There were multiple charges brought against the defendants, and the final one was crimes against humanity. In Jerusalem, though, there were multiple parts to the indictment. The truth of the matter, the focus was on one crime, the annihilation, the crimes against the Jewish people. At Nuremberg, of course, the representatives of the victors had sat in the tribunal bench, and most people there had been some complaints and some carping about that, certainly amongst Germans, but generally that was accepted. Contrast that with what happened in the 1960s when Israel made it clear that it would speak on behalf of the victims. Media outlets throughout the world, writers, opinion makers, were tremendously critical of this decision. How could the victims judge fairly? Some of the most vituperative criticism came, not surprisingly, certainly in the United States, from Jews who had found a comfortable home in the highest reaches of the non-Jewish world. For instance, Harvard professor Oscar Handlin, who was an expert on immigration, a professor of history at Harvard, who actually in the 50s had written on American Jewry, which was not a common topic for Harvard professors to be the least bit concerned with. But in a speech at Harvard and in subsequent articles, he lashed out at Israel for trying Eichmann. He saw it was an act of revenge in the satisfaction of a private offense. Strange way, certainly, of describing what had happened. He ignored the fact that, of course, Eichmann had escaped from a POW camp, entered Argentina under an alias, lived clandestinely in Argentina. He accused Israel of violating, quote, Eichmann's right of refuge with an underhanded kidnapping. And he went on and with even more severe criticism. Rabbi Elmer Berger, who was an intense anti-Zionist, the leader of the anti-Zionist American Council for Judaism, declared it Zionist declaration of war, and also the psychologist Erich Fromm, also an anti-Zionist, called it an act of lawlessness. Now, these three people, I'm just giving you three examples, there were others as well who were critical, but of course these three Jewish voices became very useful to the non-Jewish voices who were critical of Israel for this action. But there were even Zionists, such as Nachum Goldman. I believe, Chana, in your book you deal with this as well, the president of the World Zionist Organization, possibly reacting to this wave of criticism, suggested that Israel try him, but the chief judge be someone for a foreign jurist, a non-Israeli jurist. Now, Ben-Gurion, of course, who had no love lost for Nachum Goldman and vice versa, considered Goldman's critique a public slap at Israel's sovereignty, and he accused Goldman of having an inferiority complex. He thought it was hypocritical of Goldman to suggest this. He also thought it hypocritical of Goldman to be head of a Zionist organization and not live in Israel, but that's for another conference. But then you had groups in the United States, as the American Jewish Committee, which represented the mainstream of American Jewry. And Ben-Gurion had been very anxious after the establishment of the state to ensure that the people associated with the American Jewish Committee and the fellow travelers of the American Jewish Committee, to use a word that we heard this morning, be supportive of not only Israel, but supportive of this trial. The American Jewish Committee was tremendously disturbed by the trial, and they tried to convince Ben-Gurion, again, not to have it in Israel, to allow it to be tried someplace else. The problem was there was no place else. There was no international criminal court. There was an international court, but it was only for hearing cases between nations. And of course, what many people ignore is the fact that Germany, so many people said it should be held in Germany, and the last thing, of course, that Konrad Adenauer wanted was to have the Eichmann trial in Germany. There were even this very, it reads today, when you read about it, it almost reads amusing, but it must have been infuriating to Golda Meir when a group of American Jews from the American Jewish Committee sat down with her, and they said they knew at that point that it was impossible to convince Israel not to hold the trial. But what they did instead was say, instead of emphasizing crimes against the Jews, these are Jewish leaders of the American Jewish Committee, you should emphasize crimes against humanity. And the example they gave Golda Meir was say, just recently we had a wave of attacks on synagogues in the late 50s, early 60s worldwide. There had been a number of attacks on synagogues. And the leaders of the American Jewish Committee said to Golda Meir, and when we talked about these attacks, we didn't say attacks on synagogues, we said attacks on houses of worship. In other words, you say you're so much at home, but you're afraid even to say, because they were attacks not on all houses of worship, but on Jews. The final anecdote about this period that I want to share was at one point a journalist was interviewing Ben-Gurion, a journalist from the American University's field staff, an educational organization which had a very well-known publication, and the journalist was interviewing Ben-Gurion, and he suggested it might be best that the Eichmann trial not be held in Israel. And Ben-Gurion exploded. He said, "You think we should not try Eichmann? You're a Jew, an American Jew." And when the guy said, "No, I'm not a Jew. I'm not Jewish at all," Ben-Gurion continued and said, "I thought only an American Jew would question our right to try Eichmann." Of course, the trial eventually, as we well know, those criticisms were set aside and the trial went ahead. Ironically, and again, just as a footnote, because I'm sure many of you are familiar with this, one of the people most supportive or enthusiastic in her support of holding the trial in Israel was Hannah Arendt, who wrote to Karl Jaspers in an exchange. When Jaspers said to her, maybe it shouldn't be in Israel, she wrote back, "We kidnapped a man who was indicted in the first trial in Nuremberg. We abducted him from Argentina. We did not take the man to Germany, but to our own country." And then she added, "Israel," and I quote, "has as much right to sit in judgment on the crimes committed against their people as the Poles had to judge crimes committed in Poland." And in fact, I wondered, how come there was so much question about whether the Jews could be fair? Nobody had asked that question about whether the Poles or the Czechs could be fair when they had tried the Nazi war criminal. But the biggest difference between Nuremberg and Jerusalem was, of course, and again, this has been said by a number of the speakers, but to emphasize it was the role of the victims, particularly as witnesses of Holocaust survivors. At the time of Nuremberg, though, and again, we heard some of this morning about the Jewish organizations in general, but the individuals as well, the voice of the victims was hardly heard at Nuremberg. In contrast, by 1961, Hausner made a decision, a very serious decision that the voice of the victims should be center stage. This was, in fact, partially as a result of something suggested to him by Rachel Auerbach, and Boaz has done some very important work on that that's been helpful to me as well. So, and that probably is probably one of the most striking differences. Ironically, the judges in their decision said, the witnesses was very interesting, but it has no impact on us. We're going on the documents. When that's probably the one thing the judges at the Eichmann trial got wrong, because in terms of a legacy, it was the voice of the witnesses there that has been so important. Let me turn now to Irving versus Penguin and Lipstadt. My personal and legal encounter with David Irving and with the anti-Semitism that is clearly at the root of Holocaust denial and which so motivates David Irving began with just a few pages. And not all together, cut and paste. If you cut and paste all the references to David Irving in my book, Denying the Holocaust, maybe you'll get 2 pages, 200 words, 300 words, something like that. Now, they were pretty strong words. I described David Irving as the world's leading Holocaust denier. Now, just before I go on to my description, since some of you may not be familiar with that, with Irving himself, at the time when I wrote my book on Holocaust denial, which came out in '93, Irving was arguably the world's leading Holocaust denier. Why? Because he was one of the few deniers who had a reputation separate and apart from being a denier. The others were famous for being deniers. David Irving was a prolific author on World War II. Many of his books written before he became a denier, when you go back and look at them, are very problematic, laced with anti-Semitism. But his books were very much were well read. They sold well. He wrote well. His German is impeccable, and he had hovered at the edges, at the periphery of denial. We see it in his book in the late 70s, his book Hitler's War, where he makes an argument which is going to sound ludicrous to anyone in this room who's not familiar with it. Even if you are familiar with it, it's a ludicrous argument, that Hitler didn't know about the Shoah, and when he heard about the Shoah, he tried to stop it. That book he published at the end of the 70s. Anybody who could publish, he was looking to whitewash Hitler. Hitler is his hero. And this was how he was trying to whitewash him. Subsequently, after he becomes a denier, he begins to find a very comfortable home amongst deniers, particularly but not only in the United States and in Canada. And then he reissues Hitler's War. And if you sit with the 1991 edition next to the 77, 78 edition, and you compare the two, the Holocaust has disappeared from the second one. It just simply is gone. One of the things that changed him was also a legal proceeding when he testified at the Zundel trial, the trial of Ernst Zundel, who was being tried as a Holocaust denier in Canada. When he issued the second edition of Hitler's War, he was asked by a reporter why he had eliminated all references to the Holocaust from the new edition, and he said, and I quote, and this was to a reporter, so he knew it was going to be published, "If something didn't happen, you don't even dignify it with a footnote." So he was clearly, denying the Holocaust. He denied the use of gas chambers to kill Jews. He argued that there was no officially sanctioned program to annihilate world Jewry. And then, in probably one of his more outrageous statements, he said that Adolf Hitler was probably, and I quote, "the biggest friend the Jews had in the Third Reich." He was the one doing everything he could to prevent nasty things from happening to them. Now, of course, as he said these kind of things, an interesting thing happened, because I spent a lot of time reading the reviews of his books and his comments and scholars' reviews. And one might have expected someone who makes outrageous statements like that, people to say, finished. Gamarnu, forget him, But instead, you got what I call the yes, but approach. Yes, of course, that's ridiculous about he didn't know about the Holocaust. Yes, that's ridiculous that there was no Holocaust, but everything else he says is important, is worth looking at. Instead of saying, anyone who could say that, I'm not going to pay attention to anything else. So I described him in my book after reading all this and reading things like speeches he gave where he said, I'm going to sink the battleship Auschwitz, or more people died in Kennedy's car at Chappaquiddick than died in the gas chambers at Auschwitz. Statements designed to make people angry. So I described him in my book, quote, as a Hitler partisan wearing blinkers, who has been accused of skewing documents and misrepresenting data in order to reach historically untenable conclusions. And then I said, on some level, Irving seems to conceive of himself as carrying on Hitler's legacy. Strong words, but I stood behind them totally. The book came out in the United States, very positive reviews, and there was nothing he could really do to me in the United States. First of all, in the United States, libel laws, if I want to say you libeled me, I have to prove you libeled me. The burden of proof is on the person who's claiming that they were libeled. In England, the book was bought by Penguin UK, came out in England. In England, if I say you libeled me by what you wrote about me, you, as the author of the words in libel or the speaker of the words in slander, have to prove the truth of what you said. So the burden of proof is on the originator of the words. The case law reads, words spoken are considered untrue until proven true. So consequently, when the book came out in the United States, he would have had to go after me to prove I was wrong, and so he waited till it came out in the United Kingdom. There was another reason why he waited. In America, we have something called the public figure defense, which is based on a Supreme Court case from the early 60s, which says that a public figure, a politician, an author, someone who, of their own volition, of their own choice, puts themselves in the public eye, cannot sue for libel or for slander unless they can prove malicious intent. No, if someone writes about something, you can't say, oh, they only write, and you attack them in a review, they can't attack you, they can't sue you back. Now, if you say they're an axe murderer when they write about the Civil War, of course they can sue you for, they don't lose their coverage against libel on everything, but in their field of expertise, because the Supreme Court ruled that to do otherwise would put too much of a chill on freedom of speech. So, and that protection doesn't exist in England. Consequently, he waited till the book came out in England, and then he sued me. I believe that Israeli law very much is parallel to British law in that case. In any case, it was, when I remember first getting that letter that he was suing me, and I thought it was totally ridiculous, and I just sort of threw it on a pile. But then I began to get letters from Penguin that you have to take this seriously. I therefore, one of the best things that ever happened to me was I got my own lawyer, a man named Anthony Julius, who has written subsequently, plays a very important role fighting anti-Semitism in the UK. I'll tell you a funny story. It's not in my paper, but I think it's worth telling. Anthony, when someone suggested to me that I call Anthony Julius, that he would be probably willing to represent me, that he was smart, that he was clever, two different things, but if you're looking for a lawyer, you want smart and you want clever, and that he would probably do this pro bono if necessary. So again, I had heard all the important words: smart, clever, pro bono, chinam, So I said, what is his name? After he was described to me, they said Anthony Julius, and I said, oh, I know that name. I remember this is early 90s. And I said, didn't he just write a book on T.S. Eliot and anti-Semitism and literary criticism? And the person began to laugh. He was laughing at me. I had said something that really amused him. I had no idea what it was, but I decided in my usual style, just to barrel right through, to ignore the laughter. And after he stopped laughing, I said, "Oh, isn't he also Princess Diana's lawyer?" This was just at the time of Diana's divorce. You may remember that. And he said the reason he was laughing is I was probably the only one he knew, or anyone in the whole of the UK who would say, author of a book on T.S. Eliot and anti-Semitism, and also Princess Diana's lawyer. What happened, as soon as Anthony took it on, a number of things happened. First of all, the interest of the British press grew markedly because he was one of the most prominent lawyers in England. But other things happened as well. We began to devise a legal strategy. Now, in the UK, libel defendants have various legal options. They can argue that the plaintiff is misinterpreting the words in question. But the truth of the matter is, Irving wasn't misinterpreting. I meant everything I said. They can also argue, plaintiffs can argue that or defendants can argue that the words were not defamatory, but they were defamatory. I tended to criticize him and criticize him quite severely. But finally, you can claim, and this is what we did, justification is as it's called in British law, that the words at issue were true, and even if they were defamatory, I was justified in writing them. And that is called generally the atom bomb defense amongst British lawyers. We didn't have to prove every detail of the libel, but we had to prove in general that what I had said was true. Because we decided that was what we were going to follow, justification A. B, we also decided that we would argue that Irving subordinated the truth for ideological purposes, that he was a racist, that he was an anti-Semite, that he was intended to spread anti-Semitism and engender sympathy for the Third Reich. Now, once having set up how we were going to do this, our strategy, we had to figure tactics. And one of the first things, and this was really Anthony's decision, and I fought with him on this a little bit, was that we were not going to call survivors as witnesses. And one of the reasons I fought with him is that I was being inundated, as word began to spread of this, of survivors who wanted to come forth and testify. And one of the reasons that we would not call survivors, there were a number of reasons. Officially, the reason was we didn't want to give, we wanted to go into the court with the Holocaust established as fact. What happened in the Zundel trial, some of you may remember, may know, there were two trials. And in the first, because there was a hung jury at the end of the first trial, because the judge didn't take judicial recognition of the Holocaust. In other words, the Holocaust is a fact, and we're not going to debate that. And we didn't want to suggest to the judge, this was a bench trial, not a jury trial, we didn't want to suggest to the judge that there was some debate about the existence of the Holocaust. Holocaust survivors would have been witnesses of fact, the fact of something happening. Historians are expert witnesses. We didn't want to bring in witnesses of fact to suggest to the judge that there was some debate about the fact of this. That was the official reason. The unofficial reason was that David Irving was representing himself. And we didn't want to put a survivor in the witness box to be cross-examined by a man whose objective we assumed would be to humiliate them, to confuse them, and it's easy to do. You were deported from Budapest on May 23rd, 1944. And you say you arrived in Auschwitz and your family was immediately taken to the gas chambers and killed. Well, here's a document showing that that week the gas chambers were broken down or the ovens were broken down or something. You can be off by a day. You can be mixed up. You can be the whole, and again, I'm bringing coals to Newcastle by telling an audience such as this, but the whole deportation process was designed to keep you confused, for there to be chaos, for there to be noise, for there to be lights and in the darkness, and et cetera, et cetera. So it's easy to make those kind of little mistakes, which are normal. we didn't want Irving to jump on them and to humiliate or subject survivors to that. We remembered there was an incident in Melbourne where he had been on the radio with a survivor who had gone on to challenge him, Mrs. Altman, and he pointed to the number on her arm and he said, "How much money have you had from having that tattooed on your arm?" So we just didn't want to do that. Instead, we brought in literally an A-team of expert witnesses. Richard Evans was our lead historical witness, Christopher Browning, Robert Jan van Pelt, Peter Longerich. And what we essentially did was follow the footnotes. Follow Irving's footnotes back to the sources, which is why I call my book History on Trial, not Holocaust on Trial. Follow them back, and we showed, not in most cases, and not in the preponderance of cases, but in every single case where Irving wrote something about the Holocaust and footnoted it or cited a source, and you went back to the original, you found an invention, an inversion of dates, putting people at a meeting who weren't there, all sorts of manipulation of history. So much so that Richard Evans said at the end that if he were to meet David Irving and David Irving were to say to him good morning, he'd look outside the window first to check if it was indeed morning. Ironic, one of the things that happened that links, and it's just a small, didn't really affect us in the trial, but it was an interesting kind of thing, and the press, of course, reported it heavily. During the trial, a student of mine said, who had been in Israel a couple of years earlier, when there was a debate about Eichmann wrote a number of memoirs, but the memoir he wrote when he was waiting for the decision of Beit Mishpat Elyon after the original verdict, so I guess between December and the spring of that year. And it had been sitting in the archives. Nothing had happened with it. The Eichmann sons had asked for it, so it was a matter of debate when this student was here. I think it was 95, 96, something like that. And there was debate about whether Israel should release it to the family, not release it, et cetera. And in the spirit of the Middle East, nothing happened. It just went on being debated. And so then we decided that we would try to see if we could get it, see if there was anything in there of any importance to us. And also, to my mind, it was a good way of getting it released to historians. It was not the document that came out in the 80s. It was a subsequent one, which is now, as Don pointed out to me, is about to be issued in a scholarly edition. And we did manage to get it out, to have it released. It came at the final day of the trial, but my barrister did make reference to it because Eichmann makes specific references to the killing process as well. Ultimately, the Nuremberg trials, the State of Israel versus Adolf Eichmann and David Irving versus Penguin UK, have one thing in common. That, of course, is, and again, I'm bringing coals to Newcastle to an audience like this, that is anti-Semitism. At Nuremberg, the topic was addressed most obliquely. In Jerusalem and in London, it was front and center. We made a very direct argument to the judge that the thing that motivated David Irving, that caused him to say these things, was anti-Semitism. And it's interesting, one of the things that I had pointed out to my lawyers, that Holocaust denial would be impossible but for centuries of anti-Semitism. Deniers argue, if you had the unlucky situation, I'm flying 2 days from now, so maybe this is why I give this example. If you had the unlucky situation of sitting down on a plane, you're in 17A and in 17B, some guy sits down, and you turn to him as the plane is taking off, and just to be friendly, what do you do? Oh, I write about the Holocaust. You say, oh, the Holocaust interests me. I think it's very important. And then the person says it never happened, and you get the next couple of hours someone explaining to you how it's all a myth. Well, if you didn't know much about the Holocaust, the question that would come to mind is, why would the Jews make up such a story? What's in it for them. You know, I have a rule, by the way, just on the airplane example. I never talk to the person next to me, whether it's a 90-minute flight or a 9-hour flight, until we're about to land. I figure, you know, as he said, they say, fasten your seatbelt. I ask them if they're really interesting, I'll get their card and I'll be in touch with them. If they're a nutnik, I can take the next 20 minutes, so keep that in mind. But back to the topic, deniers will say that the rationale they will give you for Holocaust denial is the Jews make this up to get two things. What are the two things they, and I put in big quotation marks, got out of the Holocaust? And what do most people say? Compensation, which is a fancy word for money. And the second thing many people would say, not probably the people in this room, but what? State of Israel. So by giving these two explanations, what deniers are building on is the model, the template of anti-Semitism. If you go back to sort of the origins of the anti-Semitic imagery, which I find in the New Testament and in the death of Jesus, of course, the explanation given is that, you know, everybody in the story, of course, is Jewish except for the Romans who actually killed him, but that's a fact. We're going to set that aside. The way the story is understood for millennia by countless millions, billions of people is that, you know, of course, the Jews killed Jesus because he wanted to chase the money changers out of the temple. So the innocent Jesus suffered because Jews had a financial interest. Jews were tricky. Jews were sneaky in that. So that's where you get not only, but I know there are many people here in this room who work on this, so there are many shades to it, but that's where you sort of get the continuous themes that we find so common in anti-Semitism. Jews' financial machinations, and they're doing things to harm innocent other people. And at the expense of other people, they do these kind of things. They may be small in number, but they're able to marshal others to do their work. So what deniers are doing is giving the person who, and if you live in the Western world, you've been exposed to anti-Semitism, giving them a rationale that makes sense. It's the same thing in my country with racism, particularly against African Americans. You give a rationale, shiftless, lazy, not working, and it makes, they don't like to work, they cheat the system, whatever it might be. You give a rationale that fits into the stereotype. I'm not saying truth, just like with anti-Semitism, but the stereotype of the African American that makes sense to the individual. So anti-Semitism was at the heart of my trial as well. But in certain ways, there's something that made Irving v. Penguin and Lipstadt dramatically different from Nuremberg and Eichmann. Namely, in Nuremberg and Jerusalem, the Nazi was on trial. The Nazi or Nazis were the defendant. In London, it was the Holocaust historian who was on trial, and the claimant or the plaintiff, David Irving, the one who brought the charges, was admittedly someone whose sympathies were with the Nazis. Irving didn't want to murder anyone, Irving didn't want to hurt anyone, but he certainly wanted to obliterate the memory of what happened. In Nuremberg, there were hardly any witnesses. As I said, in Jerusalem, the witnesses were front and center, and in London, of course, they were absent, but they were absent for legal reasons. Finally, you know, at the end, I had been warned shortly before the end of the trial. Funny story, this audience will appreciate it. Towards the very end of the trial went on for 10 weeks. I was invited to Friday night dinner Shabbat dinner at a friend's home, and when I came, I was introduced to someone who was present, a judge on the High Court, a member, you know, of the British judge, a Jew who had to get permission to come to Shabbos dinner from the highest judge, the chief judge of the United Kingdom, because there was going to be a defendant there who was involved in a high-powered, high-profile trial, so it shouldn't come out through the press or something that he had gone, so he had to make sure that it was okay. And I found this quite amusing, that the chief judge of the United Kingdom was determining whether one of his colleagues could go to Shabbos dinner. But he had said to me, Deborah, I hear you're doing very well. I don't know what the judge is thinking, but my clerks are there very often, and they tell me how well your lawyers are doing, that you're showing Irving up to be a liar, a manipulator of history, etc. I said, well, I want to beat him quite badly. He said, well, most judges won't do that. British judges will write, on the one hand, Lipstadt said this is true, but she went overboard, very even-handed. As it turns out, the judgment was not even-handed at all. Let me just quote some of the words the judge said about David Irving. He perverts, he distorts, misleading, his conclusions are unjustified, it's a travesty of history, reprehensible, and unreal. And finally, that he doesn't do it, these weren't just mistakes, but this is all done on purpose. So it was, in that sense, a very, very important important decision. I don't think it put an end, would never suggest that it put an end to Holocaust denial. I think for the time being, it did seriously limit what I call hardcore Holocaust denial, the kind of David Irving, the kind of Robert Faurisson, the kind that says no gas chambers, no final solution. I think that what we have now is much more soft-core Holocaust denial, insidious kind of comparisons, and again, I don't have to describe them to this audience, you're well aware of them. The final point I want to make before I conclude is that there were many people who felt I shouldn't fight this trial. There were certainly historians, one of the leading Holocaust historians, who said to me, Deborah, you're making a big mistake, you're wasting your time, no one will take it seriously. I said, but if I don't go fight, because remember, the burden was on me. If I didn't go and challenge his charges, he would have won by default. I said, no one will believe it. The other group that was very much against me fighting this was the leadership of the British Jewish community, who invited me to a dinner with all the leading figures of the British Jewish community and suggested to me that I settle. Because David Irving, before the trial began, because David Irving will get publicity. And he'll win just by virtue of getting all this publicity and this attention. And I said to them, what do you think I should settle for? What should be my bottom line? 3 million Jews, 2 million Jews, 1 death camp, 2 death camps. In other words, what you're suggesting is ridiculous. I never would have brought this to a court. I never would have, I don't believe history belongs in the courtroom. Sometimes it's there by virtue of things that happened. But once we were brought to the court, we used history to fight this battle. It was, I think, really in many respects, it was important in terms of decimating a Holocaust denier, but it was also exceptionally important in terms of showing, while we differ on many things about the Holocaust, a number of us over lunch were going fast and furious, different interpretations of what happened and different explanations of different aspects of the Holocaust. And I know just looking around this room, there are many different interpretations, but we know it happened. And to show that you can have your opinions, you can have your perceptions of certain things, but ultimately, facts are facts. The final point I want to make, and with this I close, is that during the Eichmann trial, there were many reports, and I read tremendous press on this, of people who felt, and Achan, I think you found this as well, people who felt that Hausner had failed because he never got Eichmann to say, yes, I am a Nazi. Yes, I admit I did wrong. And of course, that was ridiculous because he was no way he was going to say that. There were many people who kept saying to me before the trial, during the trial, hopefully you'll get David Irving to admit he's a liar, to admit he doesn't tell the truth. I told people I had no expectation that he would fall on his sword in that way. He wasn't going to do that. He is a man, as are other deniers, who make their lives, their life work, lying about the truth. And they will go on to do that. Some will do it in the hardcore fashion, as David Irving does it. Others will do it in a more softcore fashion, squishier. I don't know how you could translate that, but if you're listening, maybe a much less tangible fashion. But it's not going to go away, just like anti-Semitism will not go away. At Nuremberg, the perpetrators and the documents had been at the center. The victims had been a sidebar. In Jerusalem, of course, Hausner's determination that the victims would be at the center came true. What happened after both the Nuremberg trials and then the Eichmann trial was a proliferation of historical research that's been referred to a number of times, amongst them certainly Hilberg's work and then the work of many, many other historians. What happened after my trial, and I feel maybe most gratifying with this, I close by the fact that after the trial, both not just the expert witnesses who testified, but numerous others and young graduate students, some of whom helped us with their research, began more serious investigation of the actual killing process, of how it happened, what happened, how it was done. Things that we always took for granted were investigated and studied and historically documented more so than before. So in the long run, it was a long, long battle, and I don't, when it first started, certainly I kept wondering, why me? But maybe to quote, my middle name is Esther, to end with a quote from the book of Esther, Mi odea em le'et kazot. Of course, Mordechai says he got la malchut. I don't think being sued by the world's leading Holocaust deniers malchut of anything, but mi odeim le'et kazot, who knows if not for this reason, everything I did before came to that. It's a battle that doesn't end, but I think this had an important moment in history. Thank you very much.